Now, what are we done with, people? We are done with moratorium. Correct? Huh? So, in detail, suspensions are no new suit, no transfer of assets, alienate, encumber, beneficial interest, all that part, people. Any security interest shall not be foreclosed. So, fourth one, people, no one can recover any property during this period. Supply of essential goods as well as your registrations, grants, and all, people shall not be suspended, and no one can cancel that, provided people you pay all that money. Okay. Sir, next one, people, let us concentrate on this public announcement. Sir, public announcement of CIRP. Now, people, what happens once the public announcement, once the admission has happened on the websites and all, you'll be able to see that yes, this particular thing has been admitted. Now, once the insolvency resolution professional is appointed, once he's on board, people, this person will give a public announcement. Sir, what is that public announcement? In that public announcement, people, we will specify many things. Sir, what do we specify? In that public announcement, we will say on whom has this particular CIRP has started, the name and address of the corporate debtor, authority where the corporate debtor is registered. So, people, is it like with register of partnership, or is it with the Companies Act, MCA, ROC? Basically, where are you this particular person registered? Third one, people, the details of interim resolution professional. Fourth one, people, the penalties for misleading claims. If at all you give a wrong claim, I will look at you. You see what will happen. The last date for submission of claims, until when the claims will be accepted. People, if you give it after that, we'll see what will happen. Date when CIRP ends. People, the public announcement shall be made. It is made within 3 days from the date of appointment of interim resolution professional. So, people, the moment interim resolution professional is appointed, when will he be appointed? People, on the date of admission of CIRP, acceptance of your application, people. So, from that date, 3 days you have time to give public announcement. Correct? All of you? Okay, sir. Now, sir, let us look at some real life example. So, people, my friend has recently joined a firm where they are the pioneers. They are doing really good with regards to IBC, insolvency and resolution. Yes, so I was closely monitoring what was happening and all. So a recent company, they have gone into corporate insolvency resolution process, very recent time. Now, people, see a public announcement for the attention of the creditors of Rich Fruits Private Limited. Name of the corporate debtor, Rich Fruits Private Limited. The date of incorporation, people, 2001. Authority where? ROC Bangalore. Corporate sin and all, people. Address. Insolvency commencement date, people, 2nd Feb 2022. Copy of order received on 8th Feb 2022. Yes, people. Basically, but the commencement is the day when the application is accepted. Yes, people. So 2nd Feb 2022. Estimated date on closure of insolvency resolution process. When we are planning to close it. People, 1st August 2022. Name and registration number. So, people, this is the person who is handling it, CS Haribabu Tota. Yes, people, address and email of the interim resolution professional. This is the person IRP. So, the details, the address, the all possible whatever email IDs and all. Last date for submission of claims, 22nd Feb 2022. 22nd Feb 2022. So, class of creditors, insolvency professional identified to act as authorized representative of creditors in a class. What is this and all? We'll see. But remember the name. Insolvency professionals identified to act as authorized representatives of creditors in a class. Sir, what is that? We'll see. Relevant forms and details of authorized representatives are available. If you just go and check there. Yes, people, submission of false or misleading proofs. See, it's a newspaper, public announcement. That is how it will be, right? Yes, people, got a fair idea how it will look. This is how your public announcement will look. Recent one, people. As I am talking, this is happening. Okay. Okay, sir, this is a public announcement made by Interim Resolution Professional. People, are you able to get it done? Are you able to get the, the flow of this particular topic, the flow of this particular chapter? Do let me know if yes or no, what you're finding it difficult. Okay, people, next one. So we will call for submission of your claims, creditors, and people in that order only, we will appoint a interim resolution professional. In that order only, people, we will appoint an interim resolution professional, IRP. Now, sir, who is this IRP? What will be his role? People always remember, he is the person who will first collect all information from the corporate debtor. So people, he will collect, okay, this many assets, okay, these are the things, everything, people, who is the creditors, who are the debtors, people, he will call for the information. He will call for the information, people, and he will form a committee of all these creditors, especially financial creditors and the people, collation of claims received. He will collect all the information, he will collate all the information, and based on that, he will form a committee of creditors. So, committee of creditors, people, generally it will be only and only of financial creditors. Exceptions are there. Don't ask me a question right now. You watch the throughout the video, because committee of creditors will come forward. So next one, monitor assets and manage operations of corporate people. Basically, when these people are appointed, the board of directors and partners, sir, their role will go down. Yes, even they will be temporarily suspended. This person will take over the management itself. Yes, people, especially resolution professional. This person, as of now, monitors assets and he will just manage the operations of corporate. File information collected with information utility. All the creditors have filed. I will take all this information. I will file it with IU. Exercise the power of board or partners. Yes, people. So their role will go down. People, this person will take it over. Is this clear, all of you? So, sir, the role of IRP. Yes, people, commencement of insolvency resolution process commence from the date of admission of the application. So even in that public announcement we saw, they were intimated on 8th Feb, but it will start from 2nd Feb, from the day they took it. Yes, people, withdrawal of application, section 12A has been introduced. Whatever we saw, one is before admission, one is after admission, before constitution, after constitution, EOI, after issue of EOI. Yes, people, let us see what is there in the book so that we won't miss anything. Yes, people. So let us see. We have seen moratorium. What is the moratorium period meaning? Moratorium is a delay or suspension of an activity. It is a temporary suspension of law to allow a legal challenge to be carried out. Yes, people. Declaration of moratorium period. According to section 14(1), people, on the insolvency commencement date, adjudicating authority shall by order declare moratorium prohibiting all the following acts. Whatever 4 things we saw. What is that? Institution of suits or continuation of any pending proceedings against the corporate debtor, including execution of any judgment, decree or order in any court of law, tribunal or panel or other authority. Including execution of any judgment, decree or court. People, what do you mean by this judgment or decree, people? Whenever a case is filed, say for example, A versus B. Now people, the moment you file it, or whenever the case is going on, this is called pending of suits. Imagine, people, A has won it. A has won the case. So people, this person will have a judgment or decree. Decree is passed in his favor. This is how we tell it. So people, whatever is a judgment or decree that has been passed, people, even that cannot be given effect. Whatever is the judgment or decree has been passed, even that will not be given any effect. Meaning you cannot go to court to enforce that decree. Not possible. Is this clear, all of you? Okay. So transferring, encumbering, alienating or disposing of by the corporate debtor any of its assets or any legal right or beneficial interest therein. We have seen this. Sir, any action to foreclose, recover any security interest, people. Sir, the recovery of any property by an owner or lessor, which the property is occupied by or in the possession of corporate debtor. Correct, people? The supply of essential goods or services to corporate debtor shall not be terminated or suspended. Yes, people, correct. Where the interim resolution professional or resolution professional, as the case may be, consider supply of goods or services critical to the protect and preserve the value of the corporator and manage the operations as a going concern basis, then such supply of such goods shall not be terminated except where such corporator has not paid dues arising from such supply during the moratorium period. So people, whatever is the money you need to pay for the supply, you have to be able to pay for that. If you're not able to pay, why will they supply? So that promise you need to give. That is what we saw. So that you are able to pay the past debts. Yes, people. Sir, prohibited acts. Acts prohibited during moratorium period shall not apply to. Sir, you said that the entire moratorium period there will be a absolute suspension. Nothing will happen. People, that suspension will not apply to these two things. Sir, what is that, people? Such transactions as may be notified by central government in consultation with any financial sector regulator. Meaning, people, imagine SEBI, imagine RBI. People, the central government will go and approach them. Whatever they say deems fit, people, that will be imposed and those restrictions will not be there. Yes, people, this depends on central government notifying any transaction. Second one, people, a surety in a contract of guarantee to a corporate debtor. A surety in a contract of guarantee to a corporate debtor. People, what do you mean by that? Sir, there is a corporate debtor. Sir, he has taken loan from ICICI Bank. Sir, it has been guaranteed by another person, people. Imagine Mukesh Ambani has given a guarantee. People, on him, there will be no suspension. This can freely go on. Now, corporate, whatever is a guarantee, people, I can easily enforce it. So there will be no moratorium suspension on the guarantee part, surety parts. That is what the law says. So such transaction as notified by central government with consultation with financial regulator or people, a surety in a contract of guarantee to a corporate debtor. Okay. Sir, effect of the order of moratorium, people. The order of moratorium shall have effect from the date of such order till the completion of CIRP. The provision is not applicable to a surety in a contract of guarantee. We have seen this. Thus, recovery proceedings, insolvency resolution process or bankruptcy proceeding against surety can be initiated even if moratorium is granted to the corporate debtor. Correct? So people, license, permit, registration, quota, concession, clearance, grant, right given by central government, state government, local authority, sectoral regulator or any other authority, people, shall not be suspended or terminated on ground of insolvency, subject to the condition that obviously same thing, there is no default in payment of current dues. Yes, people, whatever in the moratorium, you should be able to pay that. Yes, people. When moratorium shall cease to have effect, provided that where at any time during the CIRP, if the adjudicating authority approves the resolution plan, AA, or passes an order for liquidation of CD, people, the moratorium shall cease to have effect. Yes, people. After the commencement of corporate insolvency resolution, NCLT declared moratorium against corporator. Within a month of declaration, corporator disposed of his property. In line with section 14 of the code, any transaction or disposal of any assets of the corporator during the moratorium period, which is 180 days from the date of commencement of CIRP, is prohibited. A company cannot do that. Such an act of the corporator is not valid. However, as per regulation 29 of IBBI, the resolution professional may sell unencumbered assets of the corporate debtor other than in the ordinary course of business, not exceeding 10% of the total claims admitted. People, what do you mean by that? There is a person called as resolution professional. Sir, this person he has a power to sell any of the assets of the corporator which is unencumbered. Unencumbered means, people, there is no security, there is no collateral on this particular asset, which is not exceeding, people, 10% of the total claims admitted. Sir, the total people, whoever have come asking for the money, assume it is 10 crore. People, the value of the property shall not exceed 1 crore. Sir, why will resolution professional sell that? We'll see. To make sure that the corporate debtor survives during that time. So he can sell it, people, that is absolutely fine. Is this clear, all of you? Yes. Next one, people, public announcement. Section 15. Interim resolution professionals shall make the public announcement immediately after his appointment. Immediately refers to not more than 7 days from the date of appointment of IRP. So what will be given? We have seen the details to be given. The expenses, people, this is good. They can ask you somewhere. It will work out as a questionable point. Remember and go. Like a MCQ or a one-liner. The questionable point. The expenses of public announcement shall be borne by the applicant, which may be reimbursed by the committee of creditors to the extent it ratifies them. What do you mean by that, people? Now imagine ICICI Bank has applied for adjudication process. Now people, what do you mean by this? Imagine, people, ICICI Bank has filed an application of insolvency with adjudicating authority. Yes, sir. Okay. Now people, when adjudicating authority is appointing the insolvency resolution professional, sir, now he is giving the public announcement. Sir, who will bear these expenses? Someone should give him money, no? Times of India will post that free of cost. It's very expensive today. If you have to give that in now say for example a very good paper, now whatever I showed you that length, it will come to say 80,000 or 90,000 rupees. Yeah. So people, now if it's a any application, people, that money should be given by the applicant. Later, people, when the IRP, depending upon the claims submitted, people, he forms a committee of creditors. Now the committee of creditors may ratify it. Meaning, people, they may, whatever extent they feel, they may pay for that public announcement. That is what is given here. See, the expenses of public announcement shall be borne by the applicant, which may be, discretion, people, which may be reimbursed by committee of creditors to the extent it ratifies them. That also, to what extent it is left to their choice. Yes, people, very nice. Interim resolution professional. We saw IRP. Adjudicating authority shall appoint an IRP on the insolvency commencement date. Procedure for appointment, or where the application for corporate insolvency resolution process is made by a financial creditor or the corporate debtor. People, for them it is mandatory. The resolution professional as proposed in the application shall be appointed as the interim resolution professional if no disciplinary proceedings are pending against him. Where the application for CIRP is made by an operational creditor and there is no proposal for interim resolution professional is made. Now, why, sir? Why are you saying, sir, for operational creditor it is optional? People, you imagine the financial creditors and all these people who are in business, they will know this process. Will an employee know? Will a workman know about it? I mean, I get in this point. So people, it is their discretion. If they want, they can appoint. If not, people, it is not mandatory for them. If they have not proposed an interim resolution professional, the adjudicating authority shall make a reference to the board. Sir, which is the board here? So people, the operational creditor, imagine, people, they have not made a proposal. Now, sir, they have just filed the application. Adjudicating authority will intimate this to IVBI. NCLT will inform to IVBI that operational creditors have filed, but they have not appointed any, they have not proposed any IRP. Now see, for the recommendation of insolvency professional who may act as an interim resolution professional. So people, now board will, it will recommend certain names for interim resolution professional. Now, that person will be acting as interim resolution professional until committee of creditor is formed, and next resolution professional as it is will come into picture. Okay, now a proposal for an IRP is made. The proposed resolution professional shall be appointed as IRP if no disciplinary proceedings are pending against him. So if you have suggested any name, they will appoint them only, but provided the board shall recommend the name of insolvency professional to the adjudicating authority against whom no disciplinary proceedings are pending. within 10 days of receipt of reference from the adjudicating authority. Which one is this one, sir? This one. When adjudicating authority is asking for IBBI's approval, that is recommend as some name, the IBBI will recommend a name people within 10 days. If operational creditors they only gave a name, then it will be, the process will be very easy. If not given, we will go through IBBI route. Is this clear? Okay. Sir, the term of IRP shall continue till the date of appointment of resolution professional. Correct? He will come and he will take it over. Yes. The duties to be performed by IRP: collection and information people, collation, constitution of committee, monitor the assets of corporator, and manage its operations until a resolution professional is appointed. This is what I told you. He plays a major role. File information collected with information utilities, take control and custody of any assets of corporator, perform other duties specified by the board. So people do all this. Yes, people. And what are the powers you have? As per section 17 of the code, from the date of appointment of IRP, the management of the affairs of the corporator. Sir, ye important here. People, from the day IRP is appointed, people, from that day, the management of the affairs of the corporate debtor shall vest in IRP. Yes, people, all of you. So he will be authorized to act and execute in the name and on behalf of the corporate debtor all deeds, receipts and other documents, meaning people, he can sign a check. Now directors are not required for us. He can sign a check. He can enter into contracts. He can sign on receipts, valid. He can take such actions, people, as specified by the board. He has the authority to access the electronic records of corporate debtor from information utility having financial information of corporate debtor. So people, if there is any information which is filed with information utility of that corporate debtor, he can go and access them. He has the authority to access the books of accounts, records and other relevant documents of corporate debtor available with any government authorities, statutory auditors, accountants, such other persons. He can go to anyone asking for the documents belonging to corporate debtor. Clear? Sir, he will be responsible for complying with any other requirements under any law for the time being in force. Sir, exercise of power of board of directors and partners. The power of board of directors or partners of the corporator, as the case may be, shall stand suspended and be exercised by IRP. Reporting of officers or managers. Basically, people, they will help. Whoever are the officers of this particular corporator, they will help the IRP. Instructions to financial institutions. The financial institution maintaining accounts of the corporator shall act on the instruction of IRP in relation to such accounts and furnish all information relating to corporator available with them. What is this, people? Imagine, people, Kingfisher went into insolvency. Sir, Kingfisher's accounts and all are with ICICI Bank. Now, people, the ICICI Bank will listen to IRP. Whenever he tells to do payment, they will make the payment. Whenever he asks for any information, they will give him all the information. Yes, people, as the case may be. Management of operations of corporate debtor as going concern. The IRP shall make every endeavor to protect and preserve the value of the property, and he shall make effort to carry the particular operations of corporate debtor as a going concern. Basically, whatever is possible, he'll try to continue. The IRP shall have the authority to appoint accountants, legal or other professionals as may be necessary. So people, if at all the IRP feels I am in a help of an auditor, I want the help of a legal advisor, I want the help of any other professional, people, he can hire them. He has authority. He has a right to enter into contracts on behalf of the corporate debtor and amend or modify the contracts or transactions. We saw this. He has a power to raise interim finance. Interim finance. Sir, why is that? People, now in this 180 days also I have to survive, right? I have so many payments to make. What if I don't have money? He can raise interim. That is temporary finance also. Provided that no security interest shall be created over any encumbered property of the corporator without the prior consent of the creditor whose debt is secured over such encumbered property. What do you mean by this, people? Sir, for you to raise interim finance. You're raising, say, some, for example, interim loans. Sir, for that, obviously, people, the other person will definitely ask for security or collateral. Sir, the law says unencumbered, you're free. We saw that. If there is absolutely free of cost, you can do whatever you want, up to 10%. People, but if at all you want to take a interim finance on a security or a collateral, which is already with some financial creditor, then people, the law says, then such property you cannot pledge or you cannot take interim finance on such property, which is already encumbered, which is already subject to mortgage. On such things you cannot, provided no prior consent. So sir, if at all I want to give the properties of this particular thing, sir, I can give. What is that? Prior consent. Yes, that is what we saw. So sir, if this property is already with financial creditor people, on this we have already taken a loan. The law says you cannot touch that. Sir, I want that, sir, or else we don't have any other property. The law says, okay, take this person's consent. If he agrees, then you can do it. The next thing, the law says, people, sir, consent is also not required. To take interim finance on such property, consent is also not required, people, when? No prior consent of the creditor shall be required where the value of such property is not less than the amount equivalent to twice the amount of the debt. Sir, people, read this carefully. I've given you in short also. Provided that no prior consent of the creditor shall be required where the value of such property is not less than the amount equivalent to twice the amount of the debt. People, in short, no consent is required if the value of the property is at least double the value of the debt. No value of the property, no consent is required if the value of the property is at least double the value of the debt. Meaning, people, if at all I want to borrow 50 lakh and I'm giving you the property worth 1 crore, I'm at least getting 50 lakhs. Sir, then the law says no consent is required. So you need to get at least more than half the value of the property as a debt. Is this clear, all of you? Now try to read. Provided that no prior consent of the creditor shall be required where the value of such property, this is the value of property, value of the property is not less than amount equivalent to twice the amount of the debt. Twice the amount of the debt. Should not be less than, the value of the property should not be less than twice the amount of the debt. This is clear. Sir, he can issue instructions. So basically, what is the thing we saw, people? Sir, if at all a IRP wants to raise an interim finance, if he wants to write an interim finance, people, on which obviously he can do it. Sir, what about the security? People, the law says the security can be on unencumbered or encumbered assets. Unencumbered, people, you are free, you need not ask anyone's approval. Encumbered assets, people, already someone has taken the interest on it. So people, you need to take a prior consent. The law says prior consent is also not required. Sir, when, sir? Whenever the value of property is 2 times the value of debt. Minimum, people, this has to be there. 2:1 ratio should be there. Is this clear? Half at least you need to get. To take all such actions as may be necessary. Okay. Sir, manner of submission of proofs of claims to IRP. Proof of claim shall be committed to IRP as follows. Basically, people, sir, you are telling that public announcement IRP is given. Yes, sir. Now, how will they submit their proof of claim? People, for everything, there is a form prescribed. If at all you are a financial creditor, people, you have to submit your proofs in form C. If you're an operational creditor, people, form B. People, workmen and employees, people, operational creditor can be so many people. No, you can be a tradesman, you can be a supplier, you can be government. But if you're workmen and employees, people, then it will be in form D. Yes. Yes, people, details specified in Regulation 8, Regulation 7 and Regulation 9. Sir, people, see public announcement of which company is this? Sir, Kingfisher Industries Private Limited. See, like this, they will give you a form. The proof of claim is to be submitted by way of following specific forms. Can you see this para? The proof of claims. This one. Of following specific forms along with duly notarized affidavit as prescribed under Insolvency and Bankruptcy Board of India. There is some regulation. Yes. See, B, C, other financial creditors and operational creditors. What is there in your syllabus is only small. This is your in reality. Yes, people. So see, got a fair idea. People, I told you what a creditor shall submit claim with proof on or before the last day mentioned in the public announcement. The IRP shall verify such claims within 7 days. So people, he will say which is the last day. In our example, we saw 22nd February. You need to submit it from the last date of receipt, people. So, sir, 22nd Feb was our last day. So, people, within 7 days. Within 7 days of that last day, people, the IRP will take all those claims, people, and he will find out what is what is what. And within 2 days, people. So, 7 days is done. Now, after that, I'll have 2 days time. Sir, in this 2 days time, what I will do, I will file a report to the adjudicating authority certifying the constitution of committee of creditors. So people, after doing all the claims, I would have formed my committee of creditors. I have to intimate this to the adjudicating authority. Sir, this is the committee of creditors and this is their proportion of claim. Now, I told you that time what? When we are doing IRP, I told you last date for submission of claim. Sir, what if within last date we have not filed? This is what I'm telling you now. See, however, a creditor who fails to submit claim with proof within the time stipulated, he may submit the claim with proof to the interim resolution professional or the resolution professional, as the case may be, in which process it is, on or before 90th day of insolvency commencement date, or RP, that is to whom we need to file, as the case may be, shall verify every claim and thereupon maintain a list of creditors. Such list of creditors shall be filed with adjudicating authority and also displayed on the website. So people, sir, I was not able to file that particular claim within the time period given by the IRP. The creditor will still have time, people, to file it up to 90th day of commencement of insolvency, people. Sir, insolvency commencement date from whenever we admitted, we will have 90 days time. After that, people, then no one can help you. This is clear, people, all of you. People, that is the reason I'm giving you a short, and also when you're reading it from the book, you should understand what is there where. Yes, people, clear, all of you. So, sir, we have done with IRP. Moratorium is done, public announcement is done, correct? So people, IRP shall verify claims within 7 days and within 2 days of verification, file a report to adjudicating authority on constitution of committee of creditors. Correct? All of you, correct? Yes, people. Now people, let us go with this particular chain. Next, what is happening? Sir, next what is happening? People, IRP shall constitute committee of creditors. So people, 7 days plus 2 days intimated to adjudicating authority, everything is done. Constituting primarily of financial creditors. People, very, very important, people. Sir, about constitution of creditors, before knowing them, you need to know a little information of resolution professional. Yes. So first what we'll do, people, first let us understand about resolution professional and then let us go to committee of creditors. Clear? Okay. Sir, in the first meeting of committee of creditors, people, in their first meeting, they will appoint the resolution professional. Sir, generally, who will be this resolution professional, people? Whoever is our IRP, this person only will be considered as RP only. Sir, is it mandatory? No, people. You can appoint a new person also as a resolution professional. That is also fine. Yes, people will see what is a process and all. We'll start first. We'll see who is this resolution professional. So interim was a temporary person. Now this person will take us until the liquidation or until the completion of CIRP. Is this clear? Okay. Now people concentrate. Resolution professional. Resolution professional. Sir, who is this person? What is happening? People, resolution professional. People, by the way, all are same only. If I say them as IRP or RP, everyone is your insolvency professional only. IPs only. Whomever we saw, 5 pillars, all of them are insolvency professionals only. Clear? Sir, resolution professional. Okay. Committee of creditors in first meeting by 66% voting share appoint IRP as RP or replace IRP by another RP by filing it with adjudicating authority. So people, name is changing, adjudicating authority for such appointment. So people, they can either appoint IRP only as RP or people, they can replace it by another person. People, now the new person is coming, right? So people, the decision has to be forwarded to the adjudicating authority. Now adjudicating authority people will forward that application to IBBI. So sir, the committee of creditors people, they will forward to adjudicating authority. Adjudicating authority will forward this to IBBI. Now IBBI people will confirm whether you can continue or not continue. IBBI will confirm whether you can continue or you cannot continue within 10 days. Yes, people, until IBBI confirms people, this IRP will only be acting as a RP. Yes, people. So people, forward the name of resolution professional proposed to the board for its confirmation and shall make such appointment after confirmation by the board. Where the board does not confirm the name of proposed resolution professional within 10 days of the name of the proposed resolution professional, the adjudicating authority shall by order direct the interim resolution professional to continue to function as the resolution professional. Sir, permanently or no? Until such time as the board confirms the appointment of the proposed resolution professional. Clear? So, sir, now your doubt is, sir, within 10 days, what if IBBA does not confirm? So, people will say, whoever is our IRP, he will only continue until IBBA confirms. Yes, people, I hope you're getting. What is our main intention, people? To reduce the timelines. Is this clear? All of you? Next one, sir. Sir, role and duties of resolution professional. Sir, what will he do? People, RP shall conduct the entire CIRP from now. And people, as usual, now IRP will become RP. So he will continue to manage the operations of corporate debtor. Yes, people, and there is more. Let us see what does that say. Okay, sir, duties, people. It shall be the duty of resolution professional to preserve and protect the assets, just like our IRP people, obviously. Sir, the resolution professional shall undertake the following actions to protect the assets of the corporate debtor, namely, to take immediate custody and control of all the assets that already IRP has done, to represent and act on behalf of the corporate debtor with third parties. So people, he can go and approach, exercise rights for the benefit of the corporate debtor in judicial, quasi-judicial or arbitration proceedings. So imagine, people, now I have to approach NCLT. So people, I will go in on behalf of our corporate debtor, raise interim finance subject to the approval of committee of creditors. Interim finance, people, subject to, according to the situation, we'll see. Appoint accountants, legal or other professionals. See, if you remember that, people, same thing. Maintain updated list of claims. Convene all convene and attend all the meetings. People remember this carefully. In general scenario, the first meeting alone is conducted by IRP. In the first meeting itself, the IRP will become RP in general scenario. If not, obviously IRP only will continue. We saw the case. So sir, from that day, people, from then on, every meeting is conducted by RP. Yes, people. Okay. People, he will prepare information memorandum. What is this information memorandum? People, listen to this carefully. Preparation of information memorandum. The resolution professional shall prepare an information memorandum containing such relevant information as may be specified by the board for formulating a resolution plan. The resolution professional. Okay, now first I'll explain you the process, then you guys try to understand what it is. Sir, resolution professional is appointed. Now what will he do? People, once he is appointed, he has all the information, because as the IRP, he has only collected all the information. So people, based upon all the information he has collected, he will create one document for corporate debtor. Sir, the corporate debtor, we prepare one document, people, that document is called as information memorandum. Sir, why is this document important, people? The moment this document is created, people, now this particular document acts like a summary of your whatever are the assets, liabilities, what is the status of the company. You will be able to find it by looking at this document. How many assets are there? What is the worth of liabilities? Creditors have given their claims. How much we should pay? How much we have? So people, entire information will be there in this information memorandum. People, using this information memorandum, the resolution professional will seek for resolution plan. People, resolution plan means, people, a plan which will put our corporate debtor out of the CIRP process, so that he will safely come out of the CIRP process. So people, now imagine, people, I am a bank. I want to give you a plan. You can do this data so that you'll be able to swim through, or else you will sink. So people, I need to give you the plan. So people, for me, I need information, right? How much assets are there? How much liabilities are there? So I will take this information memorandum. Looking at it, I will give you one suggestion. That is called a resolution plan. Getting a fair idea, all of you, regarding resolution plan, again we'll go in detail. Everything you'll be seeing in status wise. But for now, understand what is the information memorandum. So now see, the resolution professional shall prepare an information memorandum containing relevant information as may be specified by IBBI for formulating a resolution plan. The resolution professional shall provide to the resolution applicant access to all relevant information in physical and electronic form, provided such resolution applicant undertakes to comply with the provision of law and confidentiality and insider trading, to protect the intellectual property rights, not to share relevant information with anyone else. Sir, now what do you mean by this, people? I prepare an information memorandum, correct? Sir, why? To take resolution plans. That is resolving plan. Sir, who will submit it? The person who will give a resolution plan will be considered as a resolution applicant. Information memorandum is prepared by resolution professional. Resolution professional prepares this information memorandum. He gives it to resolution applicants. And not only that, people, he will give access to such relevant information also, whatever they want. Because they want to know other information. By giving this resolution applicant, they need to give some resolution plan. So for that, I need to access some other information also. So people, we will take an undertaking from them. What is that? First one. Hey, I will give you the access, but make sure you keep it confidential. I'm giving you so much information. Don't give it to anyone. You need to protect my intellectual property rights. The corporate debtors. Imagine, people, Coke's, that secret is the recipe. Imagine that I am giving you access to all my documents. What if you get access to that also? and people not to share any relevant information, whatever you have got it here. Is this clear? Okay. So, sir, that is this information memorandum. Got a fair idea? Yes. See, now you will be able to find, you can connect it. Now see. Invite prospective resolution applicants who fulfill such criteria as may be laid down by him. So not everyone can become resolution applicants, no people. You should be a little, at least. So there is bigger criteria. With the approval of committee of creditors, he lays down some criteria. Only these people can come up with resolution plans. That criteria can be people depending upon the number of years of existence, your paid up capital, your turnover. It can be any such thing that can have a relevance. Having regard to the complexity and scale of operations of the business of the corporator and such other conditions as may be specified by the board to submit a resolution plan. So people, now imagine, I say that I've started taking resolution plans from you people. I will get 120 resolution plans. So people, to streamline, I say you should have a minimum experience of IT industry for 10 years. If you are satisfying this condition, only then you are eligible to submit a resolution plan. So resolution applicant, there will be certain criteria you need to fulfill to become a resolution applicant. Yes, people. Sir, resolution professional, resolution applicant are not same. Resolution professional takes the services of resolution applicant. And people, resolution information memorandum is ready. Resolution application is ready. Resolution applicant is ready. Now people, resolution plans will come. Present all the resolution plans at the meeting of committee of creditors. If you see people, that is our chain of lesson, no? RP takes over management and all the decisions of committee of creditors shall be with 66% majority as the case may be. I'll tell you that is actually 51%, 66%, 90% as the case may be. I'll tell you what is that when we are doing committee of creditors. RP invites proposals to revive corporator. These proposals are known as resolution plan from resolution applicant. Correct? Such resolution shall be submitted with committee of creditors for approval. That is what is happening here. Correct? File application for avoidance of transactions in accordance with chapter. Such other conditions as may be prescribed by the board. Yes, people. Sir, eligibility to be resolution professional. Sir, who can be a resolution professional? RP. Not resolution applicant, resolution professional only. First one, people, he is eligible to be appointed as an independent director. People, 149 subsection 6, whatever we saw when you started company law, if you are satisfying that condition, then you can become a resolution professional. Not a related party to corporator. Hey, first of all, you should be an insolvency professional. For that, you should have passed the lie. All that is there. That person only can come here. In addition to that, you need to satisfy these conditions to become a resolution professional. Yes. He is not employee or a partner or a proprietor of firm of CA, CS or CMA of the corporate debtor in the last 3 financial years. Sir, imagine people, you are a chartered accountant. You have cleared your lie exam. Sir, but you were the chartered accountant of the corporate debtor in the last 3 years. Sir, 3 years before people initiation of this corporate resolution, insolvency resolution process. If you were a CA of this particular corporator, now you cannot be a RP. Yes, people. So you should not be an employee also of that chartered accountancy firm. You should not be a partner or you should not be the proprietor. Yes, people, all three. Remember, you should not be the employee. Imagine, sir, A, B, C and Co. Sir, they were the chartered accountant of this corporator. People, you should not have worked there. You should have not been the partner there, or you should only not be a proprietor there. Clear? That is what they are saying. In the last 3 financial years, he is not people employee, proprietor, partner of any legal consultancy firm of corporator which had transaction of 5% or more of turnover of such firm in last 3 financial years. Sir, I should not be an employee, partner or proprietor of a legal firm, people. Imagine an advocate firm. I should not be an employee, partner, or proprietor of the legal firm. Sir, when, if at all, this corporate debtor has taken some legal advisory from them. So people which had transaction of 5% or more. Sir, 5% or more of what? 5% or more of turnover. Sir, turnover of what? Turnover of this firm in last 3 financial years. So people, very simple da. Whatever is my turnover in a particular financial year, in that financial year, if 5% of my turnover has come from this corporate debtor, and this condition applies for 3 financial years, I cannot be a resolution professional of this corporate debtor. Try to read it once more. Da. He is not employee, promoter or proprietor of legal or consulting firm of corporator which had a transaction of 5% or more of turnover of such firm in last 3 financial years. Yes, people? Clear? So next one, let us see the fourth note. Sir, fees, people. The fees payable to any person acting as a resolution professional and any cost incurred by the resolution professional in running the business of corporate debtor as going concern basis shall be included in the insolvency resolution process cost and shall be paid in priority before payment to any other creditor. People, the fees of resolution professional, we'll see, people, will come to the waterfall arrangement, or it is also called as payment order, priority of payment. Yeah, when we are doing winding up, I told you in IBC there is one more order. Yeah, for IBC you need to prefer that only. Yes, people. So replacement of resolution professional. People, replacement of resolution professional. What do you mean by replacement, people? Sir, we have appointed a RP at any given point of time. Can I change my RP? People, the committee of creditors to decide by vote of 66% of voting share. You can change your resolution professional provided, people, the committee of creditors feel knows that this person is not doing justice for us. 66% of the people holding the voting share. So basically, people, out of the total debt, whatever is the outstanding money, 66% of the people having it. Ideally, it will be financial creditors. Sir, they will vote, people. Clear? Okay. Committee of creditors shall forward the new name to adjudicating authority. Adjudicating authority shall forward such name to IBBI, which shall confirm the appointment. Same process which we saw here. Correct? All of you. Read it once. After the confirmation of the proposed insolvency professional by the board, he shall be appointed in the same manner as laid in section 16, which deals with the appointment of IRP. Where any disciplinary proceedings are pending against the proposed resolution professional, he cannot be appointed. People, the same thing shall continue until that person is appointed. The resolution professional shall continue with the appointment of another resolution professional. Same thing, whatever we saw here. Until this is appointed, IRP will continue as RP. Same thing here also. Until that is confirmed, RP only will continue until IBBI agrees to another person. Clear? All of you? Okay. So prepare information memorandum, people. Memorandum containing relevant information for formulating a resolution plan. That is called as information memorandum. That is whatever we saw. Correct? So people, resolution professional. Yes, we have covered everything. Yes, people. I hope you are clear. People, I hope it is going inside. Try to brush once. Sir, resolution professional, people. First of all, in the first meeting of committee of creditors, people, we appoint a resolution professional. Correct? Yes, sir. People, and if at any given point of time, if you want to replace, sir, that is also possible, people. It is not mandatory that you need to go out with the same IRP. You can propose a RP also, provided you need to pass on your name to adjudicating authority. Adjudicating authority will inform to IBBI. Until IBBI confirms people, the same interim resolution professional will continue as a resolution professional. People remember that this can be somewhere an important question. They can ask you MCQ or something here or here. They can ask you a twisted question. Try to remember that in both the places. So roles and duty people same as IRP, but in addition people information memorandum, resolution applicant, resolution plan, submission to committee of creditors, submission to AA. If AA approves, you're out of CIRP. Simple. Sir, eligibility to be RP. People, important people, they may ask you a question. Sir, eligibility people, first one, if you're eligible to be an independent director, you can be a here also. Not be a related party to corporate director. He is not people. Sir, what do you mean by related party? Sir, is it the same Companies Act definition? People, it is somewhere similar, but it is more depth here, more detail. Sir, will they ask us? Chances are less people because it's a very, very, very big definition. The chances of being asked, the related party is less people. You can concentrate on the related party of Companies Act only. But just glance. It should not be a case where we leave and go, right? Related party in relation to a corporate debtor means there are two types. See here. Related party in relation to an individual means, as it is people, for us, individual is not covered. Corporate insolvency resolution process. So we do not bother much. Correct? So not a related party to the corporate debtor. Sir, in regarding to corporate debtor, related party means, so try to concentrate on one definition, sufficient. First one people, a director, partner or relative of a director or partner of the corporate debtor. Director or partner or relative of director or partner. If you people do one thing, open your Companies Act, try to compare, almost same. We would have written as that, hey, you remember that circle like this, I would have given director, KMP or relative. People, so KMP or relative of a KMP. Correct? People, LLP or a partnership firm in which my director, partner or manager of the corporator is or his relative is a partner there. Sir, a private company in which a director, partner or manager of the corporate debtor. A private, people, I hope you are able to understand that. Imagine corporate debtor is here. Yes, sir. When will a private company, any private company, when will it be called as a related party? A private company in which director, partner or manager of corporate debtor. My director, my partner when will it come today? When corporator is a partnership firm. Director, partner or manager of the corporate debtor, people, the law is saying is a director and holds along with his relatives more than 2% of its share capital. Yes, people. So plus he's also a director plus he's also a member. How much people? Member along with relatives. How much people? Up to 2% of paid up share capital of the private company. If this condition is satisfied, this private company will be considered as a related party to the corporate debtor. It's almost similar, people. Try to read it with that, but it's an exhaustive definition. A public company, people, in which director, partner or manager of the corporator is a director and holds. He is a director and holds along with relatives more than 2% of paid up share capital. Any body corporate whose board of directors, managing director, manager in the ordinary course of business acts or advise. People, remember that circled, everything is same. We would have written. I'll tell you where this also comes. We would have written somewhere here, this point. Sir, body corporate, people. Imagine Facebook is a body corporate. What do you mean by body corporate? A company which is even incorporated outside India can be considered as body corporate. Sir, now Facebook's a body corporate whose board of directors, managing director or manager, people, they are listening to the advice of corporate debtors, directions or instructions. Corporate debtors, director, manager or manager's instruction. People, the body corporate, they are listening. Yes, people. So we consider even this people as related party, the body corporate. LLP or partnership firm whose partners or employees in the ordinary course of business acts on the advice, direction, or instruction of a director, partner, or manager of the corporator. So LLP partnership whose partner or employees are acting according to the instructions of the corporators, directors, partners, or manager. Any person on whose advice, directions, or instruction a director, partner, or manager of the corporator is accustomed to act. People, you would have written this here in that circle. Sir, our manager, our director, our partner is acting based upon someone else's instruction. So that person will be our corporator. Body corporate, which is holding people, holding company, subsidiary company, associate company, you would have written here. Yes, you just check the, see if it is there or not. Any person who controls more than 20% of voting rights in the corporator on account of ownership or a voting agreement. People, I tell you one thing, any person who controls more than 20% of voting rights, any person, people, it can be individual or a company or anything which has control of more than 20% in our company, related party. Any person in whom the corporator controls more than 20%. In previous point they are controlling, in this point we are controlling, basically associate company. Any person who can control the composition of board of directors. So people, any person who can control the composition of board of directors of the corporator. People, refer to subsidiary company definition. Any person who can control the majority composition of board of directors, it will be deemed subsidiary company. A company which is controlling majority of the composition of board of directors of another company, this company will be considered as a deemed subsidiary of this company. It will become a holding company. But of course here they have written, people, any person. So people, if it is a partner or a partnership firm, obviously this will not it will not be the same. Any person who is associated with the corporator on account of participation in policy making process, having more than 2 directors in common between corporator and such person. Sir, in my company and his company, my company and another company, we have 2 directors in common, A and B. They are directors here as well as here. They will become common, people. Interchange of managerial person between corporator and such person. So people, we have taken their managerial person, they have taken our managerial person. Provision of any essential technical information to or from the corporator. So people, if at all there is any agreement on the account of, so there is an association with the corporator with another person. Sir, in these 4 cases, sir, they will be considered as our related party. Is this clear? All of you just vaguely read, people. As far as I have seen, they have not asked a question with regards to related party. They won't ask also, because related party in some other place it's there in detail. But we cannot take it for granted. Just have a fair idea. Just keep your related party transaction notes, whatever we have seen, that circle, keep that and compare. Whatever is additional points, try to remember. What if it is covered there only? If they ask you a common or such common provision, it's easy to remember, right? So people, this is your resolution professional. Yes, people. So read till now, and next come, people, let us do your committee of creators, and from there on let us again continue. Yes, people. Okay.